can use the mic.
No,
Take a tape.
I'm gonna have them sit here.
You sure?
Yeah, that's comfortable for you. And you guys got the attorneys going first, right?
Yeah, they should just go.
I'll make that a nice
And then we're gonna have one, if it goes to both Warren and Washington, one tenant will represent both things on either side. We're not gonna have the whole.
No, yeah, of course. Yeah. It's your show. I'm just gonna let them know.
Go ahead.
Good evening, everyone. I did introduce myself before. I'm the assistant director. I can't hear you. I'm the assistant director.
I'm the Assistant Director for the Division of Housing Preservation. My name is Eric Bulwith. Tonight, whoever is coming up to provide testimony, you just have a seat right here. Be mindful of the microphone. If you would like to speak, there is a button. Just press that button. And then when you're done, just turn it off. Anyway, I'm going to let the Rent Leveling Board take over. Thank you for coming.
Okay, ladies and gentlemen, good evening. Welcome to the Jersey City Rent Leveling Board. I'd like to read the Sunshine Law statement into the record. Having been properly advertised in accordance with the Sunshine Law of the State of New Jersey, on this May 31st of 2023, the meeting of the Rent Leveling Board is hereby called to order at about 6:10. I need a roll call. When you're ready. No problem.
Al Cupo,
Present.
Sullivan Johnson, Elda Pinchinat, Joe Williams, Danon Hill, Alexander Hamilton.
Present.
Okay, we have a quorum.
Thank you. Okay. I'd like to read into the record to the public, explain procedures. First of all, we want to thank everybody for attending our meeting tonight. Everyone will have an opportunity to speak. Please speak only when recognize me as the chair. Address the board, not your adversary. Keep your presentation to the issues in question. The board will listen to all sides of your complaint or application and come to a decision. All parties will receive written decision within 3 weeks. You will then have 45 days to appeal the decision to the Supreme Court. I think this sounds familiar to the councilors too. If you do not like our decision tonight, please be civil and appeal to when you receive it in writing. I count on your cooperation tonight. I thank you. And I'd like to just please emphasize to everybody here tonight, there's a lot of people. There's going to be a lot of different opinions, I'm sure. Please be civil tonight. If not, if it becomes like a rumble, I'm just gonna call it tonight, just so everybody knows that ahead of time. The rules are explained. So now we'll call the first application, which is a legal rent petition, 100 Warren Street, Jersey City. Tenants of 100 Warren Street. Tenants attorney Neil Murata, present? Present. Okay. And Derek Reed. Okay. So I think, gentlemen, we're going to have the attorneys come up, be sworn in, and we'll start the case. But before
Be testifying, so I don't know if the need to swear in the attorneys is required.
that's fine. No, that's okay. What I would like to do, though, in this particular case, since we're being taped, we're being filmed, okay, I know this is huge. I'd like to have one of the attorneys give a synopsis of why you're back here again after being in court, after trying to work it out. We did emphasize that you guys should work it out, but we're here now, and we volunteer, just so everybody, we don't get paid for this. So please be civil, most important, okay? So, Mr. Murata, if you'd like to recap on the record, the synopsis of the case and why you're back before this particular body. Thank you.
Thank you. Neil Morado on behalf of tenants of 155 Washington, 101. This case has, can you sit up front?
Sit up front. Sit in the chair.
You can actually sit up front, Counselor.
Just press the button.
I see it's green. Is that
Yes, good.
You're good to go.
Thank you for your time tonight. I am volunteers here.
Bring the mic up to you.
There we go. Oh, there we go. Look at that.
Thank you.
Okay. So we understand that you're volunteers. We appreciate that very much. Rent control is one of the most important foundations of our society because it enables people to live in their homes. So that is the reason we're here tonight. I understand this has a long history. It goes back to early parts of last year, and the people have been passionate about it and have been to many meetings. So procedurally, the tenants submitted their petitions about illegal rent increases to this body, actually to the rent control office. The rent control administrator made a decision on those petitions. The tenants went ahead, they submitted an original brief regarding that decision. The landlord then went ahead and submitted their reply, and then we submitted a response to that, okay? So that's why we're here tonight. Briefly, I'll address the issue regarding negotiations, and I ask Mr. Reed to chime in anytime. We have discussed the matter. It's not always easy to get people together on a time basis. So it's not that we did not try to resolve the matter, just ran out of time. I think that's a fair way to put it. Other than the fact that whether we would be close or not, we never got to the point where we discussed actual settlement. Derek, if you...
Well,
Yeah.
If you want to chime in. Now's the time to do it.
I'd like you to on this issue right now, yeah, if you don't mind.
That's fine.
Is this on?
It should light up.
There you go.
Good evening, Derek Reed,
Thank you.
Ehrlich, Petrillo, Guden, Plaza, and Reed. Thank you for your attention here tonight. Again, as Neil echoed, I'll echo Neil's comments that we understand that everyone here is a volunteer, so we appreciate your time and attention. This is a very important matter. And, Neil and I have known each other for a long time, so we're not going to have any issues with us sitting next to each other here. But we do have differences of opinion as to the positions here tonight. And relative to settlement, my client did take great care to put together what they thought was a reasonable offer. And the parties, as Neil said, just couldn't agree. But there were efforts made before this meeting to resolve this. We all understand the gravity of this matter, but we just didn't get there, unfortunately.
So, on that point, go ahead.
All right, Mr. Morado, before you go any further, I'd like to bring to your attention that this board is not at full strength, okay?
Okay.
There are, I believe, if I'm not mistaken, Eric, 3 or 4 of the commissioners that are absent from tonight?
two chairs.
There's 2, okay. There's 2 absent. Do you wish to proceed, based on the fact that we're not at full strength here?
If you give me one moment, just speak to my client real quick.
Because that could definitely, determine the outcome if there's no full board.
We're ready to proceed.
Let's go. Okay.
Okay, great.
Ball's in your court. Go ahead.
Okay, thank you. If I could bring my client up, Derek, I'm sorry.
Sure.
Yeah. I also, before I proceed, I understand that Anthony Romano is here. I know he wanted to make a statement on the record. I don't know whether how you proceed with open to the public, but I'd like to introduce him so he can make his statement. I know he's a busy person, and I'm sure he'd like to be able to move on with the evening.
He's not that busy. Don't worry. Anthony,
We don't have a meeting tonight, so you're here.
Anthony, good evening.
Good evening.
Please.
Good evening, honorable members of the Jersey City zoning board. Oh, yeah.
Okay, Anthony, you're going to need to be sworn in.
You're not gonna hold the Bible, though, right?
Yeah, you can say.
Please do that now.
Sir, please raise your right hand. Do you swear that the testimony you will provide this evening will be the truth, the whole truth, and nothing but the truth?
I solemnly do.
Please state your full name, spell your last.
Anthony Louis Romano Jr., Romano.
Your address, please.
2 Marine View Plaza, apartment 22A, Hoboken, New Jersey, 07030.
Thank you. Witness is sworn.
Thank you. Okay. Anthony, you may make your statement at this time.
You want me up there?
No, you can stay right there. Microphone, you're good.
Well, first of all, good evening to the dedicated members of the Jersey City Zoning Board. Thank you for allowing me the opportunity to
Rent
speak.
leveling, Anthony.
Rent leveling, I'm sorry, rent leveling. Too many boards speaking to today. I think it's important as an elected official, I now represent this area as a Hudson County Commissioner, just to express some thoughts and feelings. Before I say anything, though, I'd like to say that I'm glad I heard the attorneys for both sides that are talking. And I'm a big believer as a police officer, when we negotiated contracts, you don't stop the talking. You don't. There's no such thing as an impasse. You keep the talking going till you work through it and you solve a problem, so it doesn't have to get to the point that it's going to get to, because in reality, there really is no winners. We don't want to have, as landlords, you don't want to have such hard feelings with the tenants, and the tenants obviously understand that that there's going to be rent raises, but you can't have it at ridiculous numbers. And I think important thing is that these buildings at Portside West and East Towers, for more than a year, they're fighting these rent increases because of 40%, which is much higher than the allowed by the Jersey City rent control law. Obviously, there's two issues here also. Where is it fall under rent control or it doesn't? But with that being said, they demonstrated that there's been a failure to meet a statutory filing requirement under Chapter 260, Section 6C, and which states the requirements. And the filing with the municipal construction officials, which I had noted in a letter that I had written, they felt was not complied with because of a time constraint. Such a filing must be made 30 days prior to completion of the construction, and it goes back to the dates when the West and East Towers were both established. The tenants have also demonstrated the required service of written statement upon them has not been satisfied, again, according to statute. So in absence of any clear evidence, they would like to know why a city-granted exemption to rent control would not have a lawful basis. I'm just asking, and I think it's not one of adversarial nature. In the world we live in right now, there seems to be too much of that. I think more than anything else, and it's been stressed to me by a few of the tenants themselves, that they would like to work together to come to some kind of agreement that is both, everybody doesn't win in a situation like this, but it has to be a fair and equitable situation that comes to pass, because they're frustrated, and I think most people would be too. Sometimes we're not here to speak angrily, because that doesn't accomplish anything. The most important thing is here to, I believe, to negotiate and to get some guidance from this board, so that, again, people work together. Landlords do have bills. Things have gone up. I think the tenants understand that, but they want to be treated fairly and within reason and in following the law. So we'd ask this board if they possibly can do that, to work with both groups. Sometimes we need those of a mediation nature. Sometimes we need to take a step out, because in a way, even though I'm an elected official, you're also officials, and you're doing a hard job. So I ask that we hear everybody out, and that there continue to be some kind of negotiation agreement and decisions being made, because it's been dragged on for so long. Some people have already lost their living places, and we obviously know that, again, the homeless situation in both Jersey City, Hoboken is constantly growing. We don't need to add to it, and everyone is entitled to a warm place to live when the weather's cold, and some place that they can call home. So we ask that, and I ask that the lawyers for the landlords, again, we don't want to treat it adversarial. Keep the negotiation, keep the dialogue going. Communication is important. Somehow, somewhere, there has to be an agreement reached, and again, with the guidance of this board. So with that being said, I'm always available to definitely talk and work with the tenants. It's obviously not a direct county issue, but I do represent them, and I want them to know that I'm there for them, along with their council representatives. And again, we have to stress, adversarial is not the word here. The word is working together, the word is frustration, and the word is to constantly communicate and not break off. And I really implore that to both attorneys to please don't walk away. Sometimes you have to sit and you could go through all hours and hours, but something has to be done because time is just dragged on for over a year, and it's just not fair to either party. And again, the tenants have to understand that, when they're shown properly that these things have gone up in price. We all know that. But at the same time, the owners have to understand a 40% rent increase is just not appropriate.
Okay.
So,
Mr.
thank you very
Romano,
much.
thank you. Thank you for your time. Thank you. Mr. Murata, Mr. Reed, would you please take your places again?
And then bring your chair up, and I can speak when you're ready.
Yeah. You want to sit or?
Yeah, sure.
Okay. Yeah.
I'm sworn in. Oh, I'm not sworn in.
No, you need to be sworn.
Yes, please.
Raise your right hand. Do you swear that the testimony you provide this evening will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Please state your full name, spell your last,
Kevin Weller, Weller,
and your addresses.
155 Washington Street.
Thank you. Please proceed.
Okay. I just wanted for procedural,
Mr. Murata,
Yes.
point of clarification. We were calling 100 Warren Street.
It's true, but
Let me finish.
Oh.
Excuse me. Let me finish. You also now are working with 155 Washington versus 100 Warren. Would you like to merge the two cases together, Mr. Reed and Mr. Murata, for the sake of, because
I
they're so
believe they have-
similar. Let me finish.
Sure.
They're so similar in nature that obviously both of them should be merged, in my opinion, for the expediency of time.
I think we're going to have to keep them separate,
Okay?
but I don't think that'll affect the time frame because I think that the one will then dovetail into the next,
Okay.
okay?
You have the,
So,
okay.
I appreciate that.
So just on a procedural note, I understand that this board has all documentations that have been submitted by all parties, appendixes, and everything is part of the record. Is that correct?
For the most part, yes. That is correct, yes.
Okay,
Yes.
thank you.
You
Okay.
you may proceed.
Okay, and I'd like to call my client as a witness. Can you please state your name for the record?
Sure. Kevin Weller.
Okay, and he has a statement to make, and then I do have some questions for him. I do believe that this will be brief. So-
Okay. Please proceed.
Yeah, as you know, I've come here for every meeting for the last 6 months, and we pretty much know how this runs. We didn't set this up to be a marathon where there's 50 people speaking. For the most part, most likely, it'll be just the two of us. Perhaps a tenant may want to say something, but we're going to keep this practical.
As long as it's civil, we're okay.
It'll definitely be. It'll definitely be.
Okay.
Okay, so greetings to the board and a warm welcome to all who have gathered here in support of this crucial hearing. We extend our gratitude to the press for their coverage as well as the Commissioner, Anthony Romano, for championing these buildings with his district and advocating for what he believes is legally just. We also appreciate the time and financial contributions made by many in pursuit of a lawful resolution to Ordinance 260 enforcement. To set the stage, I wanted to bring a few quotes that I think are pertinent. First, I'd like to quote Dinah Hendon, the former rent leveling administrator. About 100 Warren, she said in writing, signed via a wet ink signature, subject to punishment, quote, Portside was not the owner at the time the CO for 100 Warren was issued in August 1992, and evidently, the owner at that time did not apply for the exemption. End quote. Completion of construction is defined in the statute and means issuance of a certificate of occupancy. It does not mean occupancy. She also has a quote about 155, which I'll reserve for later. Lastly, let's consider some statements from Equity Residential. On their annual landlord registration statements for at least the 3 years prior to our dispute, they submitted, subject to punishment, the answer to this question. Is the property you are registering currently under rent control? They answered, yes. signed by multiple people, including a vice president of Equity Residential via his wet ink signature. Based on Equity Residential's own 10K filing filed in March of 1999 for calendar year ending 12/31/1998, they acknowledged that construction was completed for 100 Warren in 1992. They also documented the average rent per unit. Since Equity purchased rent-controlled buildings in June of 1998, but acted as if they had access to an exemption, we can calculate that Equity has overcharged Portside Towers tenants by at least $134,554,000. In court, we would seek treble damages amounting to over $400 million. Today, we are here to rectify an improper determination made by the city. And I just want to add to what Romano said. Of course, we will keep an open mind to negotiations, but in our view, the purpose of today isn't to negotiate necessarily with Equity. It's to deal with the determination by the city and the enforcement of Ordinance 260. Once this body enforces the ordinance, which we hope they will, then it will be up to Equity and the tenants and perhaps the court system to decide what happens as a result of the fact that the original owner never filed a claim of exemption. And that's basically our ask here. It's not to solve the whole problem and to figure out what would be a resolution in totality between the parties, just the city's portion. Here's the ordinance, here's what it says, and we're asking for it to be enforced. That's all. Thank you.
Thank you. Okay.
I just have a couple of brief
Please.
questions. Kevin, what is your status with the Tenants Association?
So I am the current elected president of the Portside Towers East Tenant Association.
Okay. And how long have you been a tenant?
I just signed I didn't just sign. I had one lease renewal, which was for over 35% increase after Equity Residential told me that I would have a rent freeze because I made an investment in the unit. And that's actually probably why we're here. I told them, in fact, one of the parties who's present, that if they were reasonable in their negotiation of that lease, I would be acceptable to it. And if they were to go back on what they told me, that I would find every legal avenue that was available for myself and my fellow tenants. And I said, I would hope that you'll reconsider what you're offering me. And Derek McMaster, who's here, said, I don't even need all 7 days you're giving me. We're not going to change your renewal by 1 penny. And we don't care that you spent the money that you spent on your unit. He didn't say that part. That last part I just added, but the first part he said.
Point of clarification.
Yes.
How many rooms do you hold and what is your current rent?
How many rooms?
How many rooms are in your apartment?
It's a 3-bedroom apartment.
What is it?
It's a 3-bedroom apartment.
3 bedrooms, so it's 6 rooms? Kitchen, living room, dining room, 3 bedrooms, 2 baths, perhaps?
It's 3 bedrooms, and it's 2.5 baths.
Okay, and you have a eating kitchen, galley, or what's the setup?
There's a kitchen and the living area, living room and dining room.
Living
are
room,
the
dining
same
room combination.
Yeah, it's the same room, exactly.
Yeah, and your current rent?
The rent went from $4,400 to over $6,200 in one hop.
Okay, thank you. Okay, you may proceed.
And when did you first rent?
The first lease
Approximately, when
was,
did you move in?
I guess it was 2020.
Okay. And at that time, did you receive a rental statement from the landlord?
I did not receive a rental statement prior to the initiation of my lease mentioning anything about rent control.
Okay. And at any time, did you receive, prior to your lease, a written notice stating that there was an exemption of this property from rent control?
Prior to my lease, I did not.
Okay. Also, does the building contain a landlord identification statement?
It does not. And not only does it not, when I did my initial submission, which was in July of 2022, I guess that's right, yes. When I did my initial submission, not only did I bring up in my brief that they were not in compliance with the landlord identity requirements, I actually provided pictures of every surface area of the viewable area of both buildings as part of my submission to let the landlord know they were out of compliance. And Jersey City requires full compliance with the landlord identity requirements in order to qualify for any rental increase whatsoever. And even though I demonstrated that they did not qualify, they still didn't correct it, and they still continued to charge rents. And we've had future briefs after the initial one where we brought it up again. So we were fairly shocked that they felt that they are above the ordinance altogether, that they can charge increases of rents whether or not they're in compliance with the ordinance, which seems pretty shocking to everybody.
Okay, thank you. So right now that'll be, and finalize my questions for Mr. Weller. I'm going to go into my legal argument concerning the matter. I understand that briefs have been submitted, and just to not so much reiterate what's said in the briefs, but to focus some attention on it. This case deals with, as I stated originally, a very important issue, which is rent control. Okay, rent control is a basic understanding that has come forward in this country and in the state of New Jersey in particular, and in Jersey City, to enable tenants to stay in their apartments and not face rent increases of such an exorbitant nature that has been stated here today. The statute, the state legislature has already gone forward, and they also see the need to create new construction, okay? So they adopted a statute that enables that construction to go forward, and because to coax developers into creating that construction, they provide an exemption from rent control for a certain period of time based upon the statute. The issue we have here is they did not follow, the property owner did not follow any of the requirements of that state statute, which has been incorporated into the Jersey City Rent Control Ordinance and is laid out there in full. Specifically, the statute requires that the developer files 30 days before the certificate of occupancy is issued a notice or claim of exemption. It doesn't have to be a set form. It has to be, I hereby claim the exemption, this is the property, okay, and this is the number of units, and it would pass muster under the court. That was not done by the property owner within a timely manner. In fact, it was not done by the original property owner at all. So, off the bat, we have a jurisdictional issue. They have no right to claim their exemption and to put forward that they are exempt from rent control. They did not follow the requirements under the statute. It's clear. Ms. Hendon, in her determination, when the tenants originally brought up a case out of Union City, Willow Ridge, where the court specifically stated that the statutory language is mandated, that claim of exemption be submitted 30 days before the certificate of occupancy is issued, claimed that since it was not a published opinion, they would not.
This is the point of clarification for the commissioners. This is the Willow Ridge versus Union City?
Correct.
Rent stabilization?
Yes.
Continue, okay.
Thank you. And because it was not a published opinion, she claimed that it did not have to be followed. And then she attempted to distinguish that case. The problem is, that case, that court, that appellate court, who confirmed and affirmed the determination of a Jersey City Superior Court judge on this issue. So whether it's a published opinion or not, to just disregard it, I find is improper. However, in this situation, Ms. Hendon failed to look at the other cases that are published that were cited by that appellate court in that decision. And specifically, the court says in Willow Ridge and the cases cited therein that the legislature, when they initiate a statute and they have language in that statute, that language is important. It's meant to be followed. You can't say, wait a second, it means this, it means that. If it's clear in its interpretation, it has to be followed. And in this statute, it says, a claim of exemption shall be filed 30 days before the certificate of occupancy is issued. That was not done here. What happened here, the property owner originally, who developed this building not as a multiple dwelling, which would be able to obtain the benefits of a claim of exemption if it was done right. They built a condominium building, okay, and then they went into foreclosure. The property owner,
At
the
the
predecessor.
time in the 80s, it was a depression at that point, yes.
Sure, and I understand what happened at that time. And
Logistics were
Yeah.
very, very clear.
Absolutely. I'm older than I look, I hope. No. So at that time, the predecessor to the current owner went ahead and they bought this at sheriff's sale, okay? And then the same day, they went ahead and they filed a letter claiming an exemption. What Ms. Hendon does is she takes that language of the statute and she adds something to it. She says, oh, it's not before the certificate of occupancy, it's before occupancy, okay? So she says, since nobody lived there yet, it's okay, we can grant the exemption. The problem I have with that is twofold. One, it's totally against the language of the statute, but more so, by giving that property owner, first of all, a boon. That property owner did not create new construction. That was the whole intent of the exemption from rent control, is to create new construction. That property owner did not do it. And now they come forward with a claim of exemption that they're not entitled to. Now, if they had built a building, that would have been fine, okay? We wouldn't be here tonight, okay? As long as they followed the requirements, okay? So, but in this instance, they did not do so. They were required to file the exemption letter in a timely manner. Subsequent to that, and as testified to by Mr. Weller, the property owner is required to give a written notice of an exemption. Now, we acknowledge that the leases contain an addendum that says the property is exempt from rent control. And I have it right here. The problem with that is there's two steps that have to be followed. They have to provide a prior written notice that the property is exempt from rent control. That has not been provided to any tenant in these buildings, both buildings. For the sake of brevity, this argument is the same, okay? So in this instance, okay, so the reason for the claim of exemption notice is so that the construction code official can check the building out and understand what's going on and notice, because rent control is so important, okay? This statute is taking away a right to people for rent control. So it has to be construed narrowly in that regard, okay? So the construction code official is then able to go ahead and, follow up on his obligations pursuant to code. The second aspect, as I mentioned, the written notice of an exemption that's supposed to be provided before the lease, okay? That's so a tenant knows what they're getting into. That's so they know, wait a second, my rent is going to increase by 4% next year. I'm good with that. I could bring my family in and I could have my family stay in my house. Not move in and then all of a sudden the rent is jacked up to 40%, which isn't, to me, an unconscionable increase, okay? So tenants might have another issue there, but that's not before the board tonight. So this situation is abhorrent to rent control and to the new construction statute. Again, this property owner did not build this building, did not create new construction. Another issue that bears thought is the mortgage issue. The original property owner had a mortgage. It was 1988, and it was for a 4-year term. It was a construction loan. I don't know how else you go about it. Ms. Hendon discounts that construction loan and saying that's not the type of mortgage financing that the legislature talked about in the statute. The problem is, she doesn't say what language or what type of financing the legislature meant, because she can't. There's always different types of financing.
Was the loan a bridge loan or was it permanent financing? What type of a loan was it?
One is a 4-year term loan.
Okay,
4-year
so
term, no amortization.
It was a
Okay.
strictly interest-only loan? Is that what's going on?
I do not remember the interest-only
Wasn't
factor of it.
advertised, it might have been strictly a
There-
bridge, interest only.
Whether it's a bridge or not,
Just,
okay, the fact is, and whether it's an interest-only loan or not, the fact is that it was for a set term.
right.
Okay? And that was for the full, it was not a balloon payment, okay? And that's, the legislature went ahead, when they said the type of loan that you can have, the legislature was clear. It's for the amortized length of the loan. If it was a
But you can't tell me,
four-year,
Counselor, what type of loan it was then?
I don't have it directly in front of me, so I believe Mr. Reed. Oh, I'm going to ask my client. I'll ask my client.
Please.
Go ahead, Kevin.
The loan was for $120 million. It was for both Portside East and West Towers.
Right.
And it was interest only as far as what was required to be paid, but that's not what was paid. 2 months after Portside Towers got their temporary certificate of occupancy for their demo units for condominiums and their sales office, 2 months into the sales process of condominiums, they made an $8 million payment against the loan that was not just interest. So while it was an interest loan the way that it was written, it had some certain date that all the principal and all of the interest was due, which was September 27th, 1992. At that point in time, that was just after the certificate of occupancy for the newly built condominium was issued.
All right, that's helpful. Thank you.
Yes,
Okay,
thank you.
proceed.
And that is the point.
Okay.
The fact is, the loan required that the full amount be paid by a certain date.
Can I make one more comment?
Yeah, sure.
When developers get a mortgage, this is my understanding from a year of researching this, I didn't know any of this 2 years ago, they get the kind of loan that makes sense for the kind of project that they have. And in this case, the kind of project they had didn't require an amortized loan because they weren't looking to recover it over a 30-year period of time under rent control. They weren't building rental units, they were building a condominium. So they got an appropriate loan for a condominium.
Thank you. Okay,
And the
Fair
fact, thank you. And the fact is, the type of loan that they had required a full payment of that loan. So not just interest. At the end of the day, they had to pay the whole thing off. So where the legislature said the amortized time frame of the loan is what is important, okay? Because you can have a 10-year loan with a 30-year amortization schedule, and then there's a balloon payment at the end. The legislature said, wait a second, it's not just the 10 years, it's for the whole amortized length of the loan. This was not amortized. This required full payment in 4 years. I don't understand the reliance by Ms. Hendon that because it was a construction loan, it was not initial mortgage financing.
Can I make one more comment about it?
Please.
One more point of clarification, because I think it is a complex concept. It is for me anyway. In the state statute, it's not very long. The statute's only about 3 pages long. There's a section called 84.5, which is the legislative intent. And then there's a part called 84.2, which talks about the duration of initial mortgage financing. And they're separate. The duration would get the full benefit of an amortization period if one existed. In the legislative intent section, where it talked about mortgages for construction loans, there was no mention of amortization. In fact, it said it could be a construction loan. They allowed for REITs that didn't even have a mortgage to finance properties. They weren't limiting the kind of mortgage that you could have. And if you put the two together, it seems that the intent was that you would limit any granted exemption, any valid exemption, by the duration of your initial mortgage financing. And if you had an amortization period for 30 years and you chose to pay it off in 10, you still get the full benefit of the full 30 years. You weren't penalized by paying it off early. In this case, it was a fixed 4-year loan. It could only be extended once by 6 months if you paid a penalty, then you could get a one-time 6-month extension. So I think that's the important thing. But the other important thing to consider, I believe, is that this is only determining the duration of an exemption if you actually have an exemption. But the statute is very clear that in order to have the exemption in the first place, you had to have filed, the original owner had to have filed a claim of exemption before completion of construction, in part so that you know what was being constructed. If you're not constructing a multiple dwelling, the statute titled newly constructed multiple dwelling doesn't even apply to the building. It doesn't apply to a shopping center, and it doesn't apply to a condominium that's not multiple dwelling units, which is what they built in 1992.
Thank you.
And just one clarification on that, it does not have to be filed prior to completion of construction, but prior to issuance of the certificate of occupancy. Certificate of occupancy is the document that said it's completed. So,
Counsel, you have anything else? Or-
with regards to 100 Warren, I believe we're good. Anything else?
Okay.
If I, just 1 second,
Let
please.
me just think about that 1 second.
Yeah.
I just want to make one comment about the notice requirement, because the Jersey City ordinance, while it says the only way to get an exemption, keeping in mind in Jersey City the default is rent control, and the 260 ordinance 260 is all about rent control. Then there's only one section that says the only way you can get an exemption is. And it says you have to be in full compliance with the whole statute, newly constructed multiple dwelling statute, but then it calls out two pieces specifically. So the whole thing you have to be compliant with, but we really want to focus you in on the filing requirement and the notice requirement. And the notice requirement, as he was just explaining, it's not just notice and then you're off the hook. A notice is not an exemption, right? You actually have to have an exemption to give notice about it. And so I would like to say that the landlord's inclusion of a rent control addendum claiming an exemption does not make it true, and it does not meet the notice requirement of NJSA 2A 4284.3. Since 100 Warren was not a multiple dwelling when constructed, and the original owner never filed for an exemption, there was no basis for the notice. The statute requires the notice to specify the remaining exemption period, which the notice they claim they have, the exemption they claim they have, when it would end. They did not do that either, even within the notice that they provided. Providing a proper notice would have been impossible without an exemption, and accurate information in the notice would have alerted tenants to the lack of the valid exemption. In fact, we brought this to their attention in the course of this dispute, and prior to a few months ago, the rent control addendum, like I just read, did not have the time the length that the claimed exemption would exist until, and then they added and they changed the addendum a couple months ago to say the shorter of the amortization period, or 30 years after construction, whichever is shorter, that wasn't in their rent control addendum for the first 30 years. They only put it in there after we started the dispute. They read our brief and they said, oops, our notice is not compliant, we better update it.
I would like to take that a step further. The notice is still not compliant because they did not even state when the exemption would be over.
That's true.
By just stating the language of the statute, it's not sufficient, okay? First of all, to back up, they didn't do it in the first place, okay? They didn't, so there's 4 ways that they were deficient in their language in this matter. First, the claim of exemption. Second, written notice of an exemption prior to the lease. And then in the language in the lease itself, does not set forth the time frame of the exemption as is required. But then even when they tried to correct it, all they do is cite the language of the statute. It's during the time of the amortization of the loan or 30 years, whichever is less. I don't know. I go in, I buy I rent a house, I get that language. Well, when was it built? You know, what does that mean? When was the loan? When was the amortized loan? I don't even know if there is a loan. The obligation is on the property owner to provide that information to be compliant with the statute. There is such lack of compliance with this statute throughout, they cannot have the exemption, and this property is subject to rent control.
Thank you.
I want to make one more point of clarification. That was excellent. I'm not disputing anything he just said, of course. But the filing requirement in the statute has 2 parts. The first part says that at least 30 days prior, I'm using the language prior to completion of construction because the statute defines completion of construction as the issuance of the certificate of occupancy. So that's the first part. So first you have to you have to build the right kind of building, it has to be a multiple dwelling. You have to file your claim if you want to have access to an exemption. Okay, you have to do those things. Then even if you have an exemption, the second half of that part of the statute says at least 30 days prior to the expiration of the exemption that you now have, you have to give notice again. And if Equity believed they had an exemption until August 25th, 2022, then for sure they would have given proper notice at least 30 days prior to the expiration of that filing, of that exemption. They also didn't. Not only did they not, they continued to charge above rent control after the 30 years after construction that they added to their addendum. So they're wrong in every aspect because they had no plan to ever be subject to rent control, regardless of the ordinance or the statute.
Okay, thank you.
If I may proceed, would you like Mr. Reed to address 100 or?
Go ahead with 155 and then.
Okay, sure. Is that okay? Fine, okay.
Originally, we asked for, and I believe we were granted a 15-minute break between 100 Warren and 155 Washington. If we're moving on to 155
Well,
Washington.
That is true. I forgot we did discuss that. It's okay if we recess for a moment?
Well, first, do you have questions about 100? We don't want to end
No,
100
I think
prematurely.
we'll take a break. We're off for now. Okay. We'll make it, what'd you say, 15 minutes?
That's fine.
I'm gonna make it 10 minutes.
That would be
Yeah,
fine,
10
thank you.
minutes, fine.
Okay.
Thank you.
We're off. It's a lot of gravity. It's a lot of gravity. I mean, they laid out.
I'm not,
They laid
I'm
out
a
a pretty.
believer in strict compliance to what a statute is, you know.
Yeah.
And, but are we gonna hear from the
They laid
landlord's
out a
attorney?
pretty good argument.
Sounds like they didn't do anything.
I'll listen to Mr. Reed, but I think.
But how are those facts disputed?
So here's what we're gonna do. We'll listen to Mr. Reed. They made their point. I don't know what the guy's doing with the sign, but whatever, you know. Okay. I want to hear both sides of the discussion they had about settling this. Then we'll come together, and I don't have to make a decision tonight, by the way. No. All right, as a matter of fact, we're probably not going to do it. If it lasts only one night, we'll make the decision, then come back. We're just actually thinking about that one right now. Thank you. So, yeah, all right, just so you know. So what we're going to do is we'll hear Reed, we'll hear what they have to say, we'll hear what the plans were for settlement, and then we're going to determine exactly which way we're going to go. All right, guys?
I didn't hear
Make sense? I said we'll listen to Mr. Reed's arguments, then we'll go into step 2 to see what settlements that they were trying to make. Then at that point, we will come together as a board and decide this case. Fair enough?
Because that was gonna be one of my questions. How far
We're not gonna
apart
do
were they in their own
We're
personal?
gonna let it, and we'll let 30 days go by. We'll come together, and then we'll determine which way we're gonna go. All right, gentlemen? Fair enough? That's it, okay?
I'd be curious to know.
And then after that, we're going to Waco's, and the first one's on you.
I'd be curious to know how far they
How's that one?
They were apart. And
Yeah, yeah, they're making them separate, but
yeah.
they're so close together that, pretty much. Well, we're gonna find out. We'll find out, all right?
One was supposed to be done in August. Another one was done.
Right. Well,
Right, it's really views I like. The unique views is even smaller. Big views is what I like. Right. Right. Right, that's what it's like. You get very fast. Right, but that's where you get page views, and they get annoying for finishing. any sense by looking at my own page? Does that even count? Because I was wondering about that. Oh my god, we're not doing that, Craig. We're getting like 120,000 impressions. So like it's just like a lot, and this is like it's so technical, and like we don't have like I need to hire a guy, spend like 90 grand, and then like get the numbers, and then get money.
Okay. Yep.
We don't have like a budget for that. I got nothing to do.
I didn't forget about it. Did you? I don't know.
Right, it's different, right, it's different tactics. It's just like SEO the articles, the guy can do like some of that. Versus like technical support. Right, you put it, right, you got in like, you put like into the ground. So, like a humble operation or different operations like that. You gotta develop it behind
At that point, that's on, then we're gonna get together in the huddle, we're not deciding. Decided, next meeting we'll announce our settlement. But at this point, I want to put it on the record.
Right, so why would you do it?
You guys should have your discussion.
Hi, how are you?
Do it next time too. But, yeah.
COVID and then the usual conflict.
So this way, it's
Agreed. That's the best.
very simple. We're all happy about it. So at this point, we'll hear Reed, we'll hear what the discussion is. We gotta let
You'll have to hear Reed, and then you'll have to hear the other one again on 155. There's a little bit more.
That's okay.
But that'll be brief.
But we're gonna put it all on the record tonight, and get it over with, and then at that point, we'll come together. Tonight, we're not doing that.
No, not necessarily. Because
I mean, they may, It's very true. So, you know, I'd rather just go through the motions, hear it out, and we'll have the next step. We'll determine which way.
so
And that's it, that's how we're gonna do it.
once they're done,
And you said this
you guys get your stuff out on the record, and then make a motion to reserve judgment pending
Yeah.
the next meeting.
We'll just conclude the public portion of the meeting.
Well, I think that
At the next meeting, we'll.
read this and then.
That's it.
I got it. I mean, when I say one of us, I mean me or my boyfriend. But I just want to make sure I know what they're doing versus what they should be doing. So the next meeting is not for like I think it's for a few weeks. We have delayed it because normally it would be next week because of Memorial Day. So we have some more time. But anyway.
Everybody, please come back. We'll continue the meeting. Everybody, please have a seat. We want to thank everybody for being civil tonight. Thank you in advance. Waiting for the attorneys to come back, and we'll come back on. Okay.
Thank
We're
you.
we're all back. Everybody have a seat. Thank you very much.
Thank you.
We are back on. Counsel, if you want to finish up, please, and we'll have Mr. Reed.
Thank you. Okay,
So now we're doing 155, is that right?
That's correct.
correct. Okay,
You're on.
thank you. Okay. Just to reiterate one portion, I'm not sure if I phrased it correctly, but with regards to the jurisdictional requirement, the fact that they did not file, well, with 100, did not file within the 30 days, that's a jurisdictional failure, and they cannot come forward then and claim the exemption. Now I'll go into 155, okay? 155, there is no letter claim of exemption at all, okay? The same facts that Mr. Weller stated in the beginning with regards to the rental statement not being provided, the written notice of a claim of exemption, and the other items, if you'd like, he can restate them for the record on this, or is the fact that we already?
No, I think we don't have to.
Okay, thank you. Okay, so the Ms. Hendon, whom I actually know, and I worked with Ms. Hendon before, lovely person. However, in this instance, I don't know what happened, okay? We have a statutory requirement that you file a claim of exemption, okay? Ms. Hendon says that, wait a second, it's initial occupancy. Again, the legislature does not say that, so she's making up her own language in that and changing it. Totally in derogation of the case law set forth by the appellate division in the Willow Ridge case, okay? But here, with 155, there's not even a letter, okay? What concerned me is the fact that the way it was written, it was an attempt to bootstrap what was done with one building to bring it over to another, okay? It says, well, just because it hasn't been presented doesn't mean it wasn't written or it wasn't submitted. I don't know any court or board who could accept such language. In fact, there's a rule that if you cannot present it, it means it doesn't exist, okay? So here, then Ms. Hendon tries to, again, contort the one case of 100 by stating, well, that letter meant the same for 155. It includes it. I think you have to look at the letter itself. It specifically states the number of units that are in 100. And actually, I think they got that a little bit wrong, but let's say it's correct for purposes of this time. The letter specifically states, in fact, I'm going to get the language, if you bear with me 1 second, because I think it is important.
While he's looking for that, just to be clear for you guys and for everybody in the room, the letter that we're talking about, 2 years after completion of construction of 100 Warren Street, so well after the filing requirement window ended for 100 Warren, different owners submitted a letter about 100 Warren, and they identified only information related to 100 Warren, and our landlord is trying to use that letter for a completely different property that wasn't constructed, that wouldn't be constructed for years, with a different number of units, a different number of floors, a different certificate of occupancy. Everything about the letter wouldn't fit. If you could use a letter that's too late for one building for another building, then the letter is essentially meaningless. You could use any letter for any building in Jersey City at will to overcome the needs of the requirements of the statute.
Stealing my argument.
Sorry. Well, we work on them together, so.
So,
I'm pretty sure he told me that, so.
yeah.
Are you
Yeah.
are you an attorney?
I'm not.
You should.
Oh, thank you.
So,
In summation, Counsel, go.
we're close, we're close.
He does it in less words.
We're close. So The letter states, 1 Washington Street, also known as 100 Warren Street, okay? It's specific to 100 Warren. It's not 155 Washington. The letter goes on, again, to highlight 100 Warren. References 229 rental dwelling units. It does not reference 527 dwelling units. So it absolutely only pertains to one building. It was written, I believe, before the building construction on
Years before it started.
155 even started. To try to bootstrap that letter into a claim of exemption for the other property, just because they're on the same block and lot, that's another argument Ms. Hendon used, is beyond reason. The statute says you have to give a claim of exemption detailing that property that's claimed, the exemption is being claimed for. It's not 155, it's not the number of units, 299 units, I believe. It doesn't reference any of that. So the language that you use, it's as likely as not. How, for an attorney to go ahead and express it in such a way without any proofs is just not appropriate. So I believe in this instance, with all that has been stated for 100 Warren, the property owner has failed to meet the burden to show that they have a claim of exemption on this property. There was nothing submitted for 155 Warren, and the property is subject to rent control from day one. So,
May I just add? I want to add a couple of things to that. One, I had a conversation with Dinah Hendon in May of 2022, and in that conversation, she told me that my building was subject to rent control because the original owner never filed a claim of exemption, and the new owner cannot now do that. So Dinah Hendon is the one who told me that when my very first phone call with her about the rent control status of our building. That was in 2022, May. Since that time, other tenants found that in 2020, a tenant of my building submitted a see-click-fix request. Is my building subject to rent control? And the answer came back from a city official, and the answer was, yes, your building is subject to rent control, 155 Washington. So now we have, the city said in 2020, our building is under rent control. Dinah Hendon told me in 2022, our building is subject to rent control. And then this massaging happened between May of 2022 and September of 2022, where all of a sudden, every record is perhaps a clerical error. And every document that we don't have, perhaps we just can't find it. And it just doesn't read right. And it's why we're so upset, because we're overpaying after we've been told that we're protected.
okay.
Thank you.
Thank you very much.
Okay, thank you. Mr. Reed, please come forward. Welcome, Mr. Reed.
Thank you.
You're up.
Again, Derek Reed for the record, Ehrlich, Petriello, Gooden, and Plaza on behalf of 100 Warren and 155 Washington. Again, thank you for your time and attention here tonight. I just want to remind the board that you are sitting on thousands of documents, I believe, as part of the record that was submitted to and reviewed by the Rent Leveling Bureau for the city of Jersey City in making the determination that that is on appeal here tonight by the tenants. And so I don't want to go over the whole breadth of all of those documents here tonight. We could be here a very long time. So I want to summarize that and just remind the board why we're here. We're here tonight because the tenants have appealed that decision. And the record is limited to the review of the record before the Bureau and what they considered on appeal here tonight. So certain testimony, and I understand that Mr. Weller does a very nice job, and I agree he should be an attorney. But I think there are certain things that maybe he doesn't know, such as hearsay testimony, that maybe should be excluded here tonight, such as conversations he had with Dina Hendon, such as conversations that he had with the city. There's a reason that hearsay evidence is so crucially scrutinized under the law and skeptical, because you ever play the game of telephone, right? You sit around a table, you tell someone next to you, you whisper in their ear, and by the time it gets back to you, it's something completely different. What we say in the law is you have to hear it from the horse's mouth. And we don't have them here today. They weren't called as witnesses here today to testify as to what Mr. Weller said they said. So we would ask the board to disregard that testimony. I'd also point out, I believe that Mr. Weller testified that he is a tenant of 155 Washington, not 100 Warren. That being said, the appellants argue in their appeals that the actions of the Office of Landlord-Tenant Relations Bureau of Rent Leveling, the bureau I'll refer to here tonight, in determining that 100 Warren was exempt from the Jersey City Rent Control Ordinance until August 24th, 2022, and that 155 Washington is exempt from the Jersey City Rent Control Ordinance until December 30th, 2027, was arbitrary, capricious, and unreasonable. As you know, the board typically defers to the well-thought-out and reasoned decisions of the Bureau. Ms. Hendon took a very long time to review the thousands of pages of documents that are here on this appeal here tonight, to make this decision, to thoughtfully go through them. In her years of experience with the city of Jersey City and in working with the Jersey City Rent Control Ordinance. So we would remind the board of that. And at the outset, I think it's important that we have an understanding as to what an intentionally high standard arbitrary and capricious imposes. An arbitrary and capricious action means a willful and unreasoning action without consideration and in disregard of circumstances. Where there is room for two opinions, action is not arbitrary or capricious when exercised honestly and upon due consideration, even though it may be believed that an erroneous conclusion has been reached. And I'm citing from Bayshore Sewerage Company versus Department of Environmental Protection, 122 NJ Super 184 at 199, Appellate Division 1973. I also think it's important to point out the vital public policy promoted by the new construction exemption statute found at NJSA 2A:42-84.1 at SEC, which was to address the critical shortage of newly constructed rental housing in New Jersey by encouraging private development. The purpose of the legislation was to ensure that municipal rent control would not create a financial impediment to the investment in private development of new rental housing for up to 30 years. The cost to develop and operate such multifamily housing, as the first speaker, Mr. Romano, I believe it was, testified to tonight, requires an enormous investment in capital, which could not be recouped if subject to rent control at the inception of the operation. The statute worked as devised in this case. It worked. We have two incredible developments that provide necessary rental housing in Jersey City. One building which is now fully subject to rent control, and the other soon to be in 2027. At their core, the appeals presented today seek to strip away the financial incentive created by the statute 30 years after being relied upon for 30 years. And I'll just note that Mr. Murata mentions the Willow Ridge decision and rightfully says it's not precedential, as noted by Ms. Hendon in her decision. It has no presidential effect and does not have bearing, or as according to Ms. Hendon, on this decision. And as properly noted by Ms. Hendon, there are factual distinctions between that case and this case. I now want to briefly address notable points of the Bureau's decision for each property. And again, I'm not going to get into the nuts and bolts of it. Our brief does, and all the information you have before you, certainly if you want to get deeper into it, you can. But I want to briefly just address some of the notable points here. As to 100 Warren, the Bureau's 100 Warren determination considered what effect the relative dates of several key events would have on respondents' claim of exemption pursuant to the Act. Number one, the August 25th, 1992 Warren CO, the November 23rd, 1994 Sheriff's Deed, the November 23rd, 1994 Exemption Notice, the January 1st, 1995 Anticipated Date of Initial Occupancy, and the January 25th, 1995 Warren COO. The Bureau also relied upon its finding that 100 Warren was originally constructed by a different owner-developer as a condominium, not a multiple dwelling within the meaning of the new construction exemption statute, which is defined in that statute as, quote, any building or structure and land appurtenant thereto containing 4 or more dwelling units, rented or offered for rent to 4 or more tenants or family members. And that's right out of the new construction exemption statute. The Bureau then engaged in a thoughtful and sound inquiry to conclude that the November 23, 1994 exemption notice was served to the construction official at the time, Michael Regan, and that satisfied respondents' obligations pursuant to the statute, determining that, quote, in the circumstances, this letter satisfies the notice requirement of the statute in 2A:42-84.4, and that's a quote from the Bureau's decision here. Specifically, the Bureau determined that the development of Portside Towers was not changed to a residential apartment community, a quote-unquote multiple dwelling, within the meaning of the statute until the date of the acquisition by, and I'm using an acronym here, PAURC, which I'll refer to as PARC. The Bureau recognized that this was supported by the November 23, 1994 date of the exemption notice, which was notably the same date as the sheriff's deed, and further acknowledged that 100 Warren was not occupied in any capacity. Nobody resided in 100 Warren. It was completely and utterly vacant until at least January 24, 1995, the date of the Warren COO. The Bureau also determined that the exemption notice satisfied the fundamental purpose of the statutory notice requirement, which is to, quote, provide notice to the city official who is in a position to confirm that the dwelling meets the statutory definitions, that the dwelling is constructed, not rehabilitated, is a multiple dwelling, contains 4 or more dwelling units, and that the construction has been completed, that a CO has been issued. The developer's letter identifies the property by address, block and lot, references the statutory exemption, the number of units, and the commencement date of the initial occupancy, January 1st, 1995. These are the findings and a quotation from the Bureau's decision, which is under appeal here tonight. As a result of these determinations, the Bureau found that the exemption notice served to the Jersey City Construction Code official, Michael Regan, on or about November 23, 1994, which was delivered more than 30 days in advance of the issuance of the Warren COO, satisfied the notice requirements of the statute. As to the note and mortgage, which Mr. Murata acknowledges in his presentation was a construction loan without any amortization. The Bureau considered and dismissed the appellant's argument that the subject note and mortgage was the initial mortgage financing as defined in the statute, which states, and this is from the statute, for a period of time not to exceed the period of amortization of any initial mortgage loan obtained for multiple dwelling or for 30 years following the completion of construction, whichever is less, close quote. It goes on to say, open quote, in the event that there is no initial mortgage financing, the period of exemption from a rent control or rent leveling ordinance shall be 30 years from the completion of construction, close quote. The statute also defines, and the legislature took great care here, to define period of amortization. The period of amortization as defined in the statute is, quote, the time during which the principal amount of the mortgage loan and interest thereon would be paid entirely through periodic payments, whether or not the term of the mortgage loan is for a shorter period concluding with a balloon payment, close quote. That's how the legislature defined period of amortization in interpreting and writing the statute. In considering the statute and facts in this case, the Bureau determined, quote, the note and mortgage are not what the statute would consider to be the initial mortgage loan obtained for the multiple dwelling, close quote. The note and mortgage were obtained for the construction of these multiple dwellings, as admitted by Mr. Murata. This is evidenced by the fact that in 1998, the site was a vacant lot. The note and mortgage did not have a set quote-unquote principal amount, but rather were in the amount of $120 million or so much thereof as may be advanced. Because the principal amount changed over time as funds were needed for construction, there was no period of amortization. And again, this was the determination of the Bureau. The Bureau held that the mortgage and note are not the initial mortgage loan, as contemplated by the statute. Now, I know Mr. Weller opined for some time in his testimony about the nature of the mortgage financing back in 1988. Mr. Weller also admitted that he just became familiar with it, and he wasn't trained as an expert. He wasn't qualified as an expert, and admitted that it was complicated. And so his testimony relative to the nature of the mortgage should be disregarded. The Bureau,
Please.
the Bureau took great care to review these documents, to review the initial, the note and mortgage here, and they made a determination based on how that note was set up that this was not the initial mortgage financing as anticipated or as contemplated by the statute. There was no period of amortization. And again, the appellants here tonight admitted that there was no period of amortization. As to 155, notably, 155 Washington is the same lot and block, or is on the same lot and block as 100 Warren, which is generally how properties are legally referred to. The Bureau found that although an exemption notice for 155 Washington was not located, upon careful review of the totality of the evidence, it determined that, quote, it is as likely as not that 3 years later, with the issuance of the CO for 155 Washington, another request for exemption was sent, close quote. In reaching this conclusion, the Bureau considered several critical factors, including the fact that the relevant documents are 30 years old. We're going back over a quarter of a century. I believe I was in high school. That several Oprah requests failed to reveal documents that were later discovered by continued search by the city, not to mention the discovery of the CO by the prior owner, not the city. In addition, the Bureau noted that Mr. Regan, the construction code official at the time, was unaware of his role under the exemption statute. The Bureau went on to find that, quote, perhaps in light of Mr. Regan's December 6, 1994 letter, which is in the record and part of your submissions, it was sent to some other city agency. What is clear, and these are the words of the Bureau, what is clear, as set forth in detail below, is that 155 Washington was owned by the same owner as 100 Warren, and these towers were managed as one development. The tenants were aware that this was one development. Equally important, the city was aware that this was one development comprised of two newly constructed multiple dwellings. The statutory requirement of notice to the construction code official is meant to provide notice to the city official who is in a position to confirm the dwelling meets the statutory definitions. That, again, the dwelling is constructed as a multiple dwelling and that the construction has been completed. The Bureau concluded, quote, that 155 Washington meets these criteria is undisputed, close quote. The Bureau further justifies its determination in the absence of a notice from 30 years ago to a construction official who did not discharge his role under the statute by pointing out that the city was fully aware of and acknowledged the exemption of not only 100 Warren, but 155 Washington as well, by stating, quote, the city was aware of the construction of the two towers of Portside Towers, 100 Warren and 155 Washington, which are on the same tax block and lot and are part of the same development plan, owned and managed by the same owner, close quote. The Bureau references several key documents here. The July 1992 Developers Agreement, of which the city was a party. The CO for 100 Warren, issued for 230 units in 1992. The December 31st, 1997 CO for 155 Washington that confirmed, quote, construction of a 25-story building as per approved plans, and the November 1999 Tidewater Basin Redevelopment Plan, which identifies, quote, Portside District, described as partially developed as Portside, a mixed-use development consisting of a maximum of 527 dwelling units, along with the requisite language in the tenant leases. And I would note on that point that the statute doesn't require a two-step notice. It doesn't require a two-step notice to the tenants. It requires that the tenants are apprised of the exemption, and that was done here in the addendum to the leases. That is notice to the tenants. They can decide not to sign the lease. They can decide not to enter into the contract, but they are given that notice that the property is exempt from rent control, and that is satisfies the statute, and that's what was found by the Bureau. In this context, and consistent with the Bureau's findings, these buildings have been operated as being exempt from the Jersey City Rent Control Ordinance in broad daylight, with the full knowledge and acceptance of the city of Jersey City for 30 years. As the Bureau concludes in its determination, Portside Towers was a notable development, leading the resurgence of development in the city, which was openly acknowledged and known to the city, not only because of the sheer size of the development, but as to its exemption from rent control for the past 30 years. Equally important, the owners, in reliance on Jersey City's acknowledgement and treatment of the properties as being exempt from rent control, similarly have reasonably relied on the exemption for the past 30 years. Appellant's contention that despite that 30-year track record of treating these properties as exempt should not retroactively treat them as having been subject to rent control for the past 30 years flies in the face of the legal doctrines of waiver and estoppel. The city and residents got the benefit of the development of these two buildings, which would not likely have been financially feasible if rent controlled for the past 30 years, but now seek to unfairly claw back the incentive after the units were constructed and occupied for the past 30 years with the owner's reasonable belief they were exempt from rent control. The Bureau found that they were indeed exempt. And in conclusion, we respectfully request the Board affirm the Bureau's determination from which appellants appeal. Thank you for your attention tonight.
Thank you. Okay.
Thank you. We'll be brief
Mm-hmm.
in our
Sure.
rebuttal. Um,
Please.
Thank you. Okay. So just a couple of items. One, Mr. Reed references hearsay. I would believe that this board has been advised by their counsel on numerous occasions over their history on this board that hearsay is admissible in these proceedings. So if not, I'm sure Mr. Slattery will do so. This is an administrative hearing. It is not the Superior Court, and hearsay is permitted. The way you wish to give it is up to you, okay? One thing I'd like to go right in on is the statement that 2 notices to the prospective tenant are not required, okay? And I'm going to read the statute. Statute provides in 2A 42-84.3, titled Leasing of Premises Located in Exempted Multiple Dwellings, Exemption Statements and Notices. The owner of any multiple dwelling exempted from a rent control or rent leveling ordinance pursuant to this act shall, it's mandatory, prior to entering into any lease with the person for tenancy of any premises located in a multiple dwelling, furnish the prospective tenant with a written statement, not a lease, a written statement that the multiple dwelling in which the premises is located is exempt from rent control or rent leveling for such time as may remain in the exemption period. So two factors there. You got to give the remaining time. That was never done, okay? But you have to give this notice. How else is a tenant to come forward and say, I want to make this my home, if they don't know what they're getting into, okay? Then it goes on. Each lease offered to a prospective tenant for any dwelling unit therein during the period the multiple dwelling is so exempted shall contain a provision notifying the tenant of the exemption. Two different steps. There's no doubt about it. You can't read them together. It's not possible. Why wouldn't you just have one? Okay? So, set right there. They did not do what they were required to do. Mr. Reed also references the standard of review of this board as arbitrary and capricious. First of all, I do not believe it is, because it's not the Superior Court reviewing your action, which is an arbitrary and capricious review, but you're reviewing the action of the administrator of the Rent Control Office. I do not believe it's an arbitrary and capricious review standard. However, even if it is, if the statute specifically says something, you can't go and say, okay, a CCO is good enough. That's arbitrary and capricious, because you've totally disregarded the language of the statute. The, just on that issue, okay? Going to the loan. There is no amortization in the loan. I did admit that. I'll admit it again. There's nothing in the statute that says an initial mortgage loan has to have an amortization period. The whole reason for that is, as I stated, if there is an amortization period, that's how long the exemption's going to be. Unless it's over 30 years, of course, then it's 30 years. In this instance, there was a 4-year term for that loan. That's how long it lasted. If this board finds that there is an exemption, it ended at that time. Mr. Reed then goes on to how important this project was for Jersey City. And it probably is. It's a beautiful building, two of them. His client didn't build it. His client and the predecessor, I should say, in respect to his client, the predecessor did not build this new construction. They did not do it, okay? So again, they are outside the statute. It had to be done by the prior owner, or if the predecessor had purchased the property before the construction was finished, then they could have done it at that time, more than 30 days before the issuance of the certificate of occupancy. Okay,
Let me know when I can go.
thank you. Unfortunately, the Bureau in this instance circumvented the statute. The statute is clear. The language of the courts cited by the Appellate Division in Willow Ridge specifically state that the legislature, the language that the legislature set forth, has to be followed. Unfortunately, the Bureau took a different approach. Does not follow the language at all. In fact, makes up statements, for some reason, stating they're reasonable. They're not. Mr. Weller's not being an expert. The Bureau is not an expert either with regards to mortgages. I also don't know how long Ms. Hendon was here, but I don't think it was that long, because I knew her before her tenure as, before this body. And so I don't believe it was that long. So I don't know if her years of experience come into play in this instance. But Ms. Hendon was not an expert on mortgage financing, okay? And I do not believe she relied upon an expert, because she didn't get a report from an expert as to mortgage financing. So Mr. Weller might not be an expert on mortgage financing, but he learned about the mortgage. And he was able to recite the relevant portions of that mortgage to this board tonight. So I do believe that his testimony is valid. It's up to this board to decide on that issue.
I have a few things.
Oh, and I did have one more thing. I'm sorry.
As many as you want.
And it's kind of odd. We talked about a multiple dwelling. And there's no doubt the predecessor started leasing these properties. But in 1996, they filed a master deed. It's a condo building in 1996. 2 years after, they filed a claim of exemption. That was 2 years too late. So, anyway, go ahead.
Okay, a couple things. First, I also want to address the hearsay portion. I'm not a lawyer. We've covered that one already. But some of what I said wasn't hearsay because the quotes, the Dinah Hendon quotes, and I'm going to read them again real quick, are in the record, and they are verbatim quotes from her determination that she signed and certified. And in her determination, and I'm quoting Dinah Hendon here, with an on-the-record quote that she herself wrote and signed to, Portside was not the owner at the time the CO for 100 Warren was issued in August 1992, and evidently the owner at the time did not apply for an exemption. And she also, I quote, said, completion of construction is defined in the statute. It means issuance of a certificate of occupancy. It does not mean occupancy. And she also said, and I quote, and this is a verbatim quote that she signed to, and she said, no letter to the construction code official in connection with 100 Washington Street has been located. So those were exact quotes. We also have, and it's also on the record, emails in writing from Dinah Hendon where she said 100 Warren Street is subject to rent control. We have emails, and they're in the record from Dinah Hendon. That's not hearsay. The other thing that I want to mention, what I want to mention is, yes, I'm not a lawyer. I find this whole situation to be quite the experience. It may be a surprise for you to hear that I've received some legal training. I only took one course. Would you believe what the course topic was? It was rent control. Would you like to know who taught me that course?
Sure.
Dinah Hendon. She taught a continuing legal education course on rent control, and I took her course, and I got credit for it. It's the only legal credit I have, and there are a few things that I learned in that course from Dinah Hendon. One of the things is about something called obfuscation. And one of the things about obfuscation is that in order to accomplish it, you need a lot of words. So one of the things that I did in this process in the last year, with the help of some other lawyers who have been very helpful, is we obtained a copy of every exemption request that has ever been made in Jersey City. I have every single one of them. I may be one of the few people who read every single one of them. And all of the exemption requests have a few things in common. One, generally, they're 1 page long. And they have a paragraph. And the paragraph is very standardized. It says something along the lines of, I'm making my filing of claim of exemption to rent control. I'm making this filing in anticipation of our certificate of occupancy, which we expect will be longer than 30 days from now. And they're very, very, very standardized. And I read all of them, every single one for the entire city, as long as Jersey City has records. Thousands of pages. Ours is unique. Ours, it takes a lot of pages to do what they did. So I wanted to understand that, and that's when, in combination with her legal course that I took and some reading, obfuscation. The points we're trying to make should actually fit on one side of one piece of paper. The original owner did not file an exemption, file their claim of exemption for either tower. That's clear. Dinah Hendon herself says it in her quote. 100 Warren wasn't a multiple dwelling when it was newly constructed. The only way to get access to an exemption is via the statute that's titled Newly Constructed Multiple Dwellings. When it's defining what construction is, it's talking about the construction of a multiple dwelling, which 100 Warren was not. 100 Warren was never a newly constructed multiple dwelling, so you could not possibly get an exemption for that structure. So obfuscation. It's the intentional act of creating confusion or ambiguity, and it's a strategy that can be employed by legal professionals to generate doubt or conceal weaknesses in their arguments. They may use intricate language, unrelated details, or vague reasoning to hinder the comprehension of decision makers and contest the opposing party's arguments. I feel it's necessary to shed some light on how this technique was used related to 155 Washington Street. Given the owner of 155 Washington Street never filed a claim of exemption to rent control, Equity's legal team attempted to obfuscate the New Jersey statute's clear intent to treat buildings as individual entities so it can apply a letter that was 2 years too late.
Okay.
Yeah.
Take a breath.
For one building.
Take your time, Mr.
Give me a second. To a different building with a different address, a different certificate of occupancy, a different original owner, a different number of floors, a different number of units, governed by a different tenant association with different bylaws, different elected president, and a different board of directors. The technique stands out when viewing the actual language of the statute. 2A 4284.1, the definition of a multiple dwelling. There's no S on the end of that. The statute specifically states that a multiple dwelling is any building containing 4 or more dwelling units. The definition focuses on individual buildings rather than groups or complexes. 2A 4284.2, applicability of a municipal rent control ordinance. Statute explains that rent control ordinances do not apply to multiple dwellings constructed after the effective date of the act, and that exemptions are tied to individual buildings based on their completion of construction. 84.3, notice of exemption to tenants. We heard a lot about that tonight. The owner of any multiple dwelling exempted from a rent control or rent leveling ordinance must provide a written statement to prospective tenants. The requirement focuses on the specific building in which the tenant's dwelling unit is located, emphasizing individual building evaluation. This notice would be bound by the date of the individual building CO and the duration of its initial mortgage financing. 84.4, this one's really important. Filing of an owner's claim of exemption. The owner of a multiple dwelling, singular, claiming an exemption must file a written statement with the municipal construction official. Now here's where we get a building, including information necessary to locate and identify, this is a quote directly from the statute, the specific building for which the exemption is claimed, and a statement of the number of rental dwelling units in the multiple dwelling, not a condominium, for which the exemption is claimed. This requirement again highlights the individual building focus. Now, while we don't need initial mortgage financing to determine the duration of an exemption that doesn't exist, just to be clear, because the council mentioned that we admitted that the mortgage financing was a construction loan. That's obfuscation because it implies that there's something wrong with admitting that it's a construction loan. Here's what the legislative intent, I'm going to read it from the statute. The uniform method of financing construction of new apartments was through project-based mortgage loans. There was little, if any, new construction financed in any other way. So if the uniform method of financing construction was through project-based mortgage loans, which is exactly what we have, and the statute goes so far as to say there was little, if any, new construction financed any other way, and we're trying to disregard the construction loan, turns out it doesn't matter because it only reduces the duration if you actually have an exemption. But I think it's important because I know in one of our briefs that we wrote, maybe one of the ones I wrote before we had lawyers helping us, to the degree we do, the other side said I spilled a lot of ink, and maybe I do sometimes because I'm not a lawyer. But they also spilled quite a bit of ink, and it takes a lot of ink to figure out how when you don't have a file of a claim of exemption, that somehow you're going to try and get an exemption anyway, and it shouldn't be. And we're asking that the board enforces the ordinance. It's really, really that simple. We're not asking you to solve the whole problem. If you enforce the ordinance, we're still going to have our fight, but it's going to be off the city's plate. That's what we're asking for, please.
Just-
Okay.
And just as
Still not a lawyer.
Just as a
Counsel.
Just as a matter of procedure, Mr. Reed mentioned that Mr. Weller lives in one unit, and when I had stated, is his testimony valid for both properties, or do you want me to call somebody else? I just want to know.
I think we're okay.
Huh?
I think we're okay with the one.
We're okay with the one.
We're
I just
okay
want
with
to
the
make
one.
sure. Okay.
That's fine. Okay. Thank you.
Thank you
Okay.
very much.
Thank you, guys. Any questions that you guys have? So much detail.
Commissioners?
I wish you would have questions.
There was, I thought I may have heard, and I hope I wasn't mistaken in that, there were residents that may have lost their apartments. Was that of
Yes.
their own accord? Or
There were homeless prior tenants in the room. Homeless.
Yous all have new rentals, I hope. Yous don't. Okay.
Homeless, actually.
Okay. Thank you.
Thank you.
Okay. Thank you. Have a good evening. Thank you. Wow.
Just a couple points that I wanted to bring up after that long diatribe was prior to entering into a lease, all the statute says, again, I'm repeating myself, all the statute says is a tenant has to be apprised of the rent control exemption. Presenting the lease, an unsigned lease for the tenant to review, is presenting that notice as satisfying the statute. There's no additional notice that has to be given under the statute. So that is what Ms. Hendon found. That is what the Bureau found in its decision, and frankly, that's what the statute says. Relative to the standard, well, the standard is alleged in the appellant's appeal that it's arbitrary and capricious. So that's in Mr. Murata's own appeal that he is imposing the arbitrary and capricious standard. And there must be an amortization period. Okay, it's that simple. There must be a period of amortization under the statute. That's why it's so defined in the statute. And it's one of the hallmarks of the statute. And it defines the period of amortization as that period of time for which the interest and principal are paid on regular payments. That is not what this note and mortgage was from 1988. And finally, we're here to appeal the Bureau's decision. Those are the four corners of the hearing here tonight. Not anything less and not anything more. The Bureau's well-reasoned decision that considered the thousands of pages that we have here in the record and came to a conclusion relative to this rent control exemption. Thank you for your time and attention here tonight.
Thank you, Mr.
I have a
Reed.
question for you. I have a question for you. Sure. Earlier, the tenant's lawyer talked about that you guys were at the table having a conversation about trying to resolve this, but you didn't have time. Is there any way you still can have that conversation?
With all due respect, we're going to clear the board here for now, and then we're going to have you come back relative to the fact of a possible settlement or whatever discussions you had along that. So with all due respect, we're going to bring that very shortly, okay? So, yeah, that'll be a separate item. Okay.
Okay.
Thank you, Mr. Reed. In other
All
words,
right.
that's-
Thank you.
Okay.
All right.
All right. Commissioners, at this time, I'd like to close the public portion of the meeting. Do I have a motion?
Motion to close.
Second.
Second? All in favor?
Aye.
So carried. Okay. So, counselors, Mr. Reed, Mr. Murata, I'd like to bring you back one at a time, and please explain to the board your method of trying to solve this problem so we have some kind of a baseline to work with, how you were going to try to get this thing amicably solution. So please, you could start, Mr. Murata. Thank you.
I'm happy to advise as to the steps we took. I don't think it's appropriate to go into the substance of the matter. Unless I don't know, I'd have to discuss that with Mr. Reed.
You want to take 5? We'll take off for 5 minutes. You want to discuss it with him, or? Because plain simple, this is so complex. This is way beyond our comprehension. This has been going on for so long, and frankly, we're looking for a baseline to work with to try to resolve the issue. So, with all due respect to you, I think that maybe you should. Okay, have some
no problem
indication.
speaking to,
I'm gonna ask Mr. Reed the same thing. Mr. Reed, would you have any problem with explaining how the two groups were trying to work something out amicably with the situation, or you have a problem with that?
No, I don't have, conceptually, no, but I think we need to have a conference with Mr. Slattery before the board engages in.
That's fine. No problem. Okay.
That's fine.
All right. So I think we're going to take another 10-minute recess. Okay, Mr. Slattery, if you don't mind, maybe you want to meet with the counselors. And at this point, ladies and gentlemen, we're off for 10 minutes. Thank you. I want a baseline. I want to know where they are. Yeah, that we're gonna find out. Yeah. Because this is so. Yeah, no, yeah.
I'm hearing you out.
No, I do too. But I want to give everybody the opportunity to at least talk.
Yeah.
Like you said, keep it going. Keep it going. Sure. Well, let's see what they say. And we're not going to determine it tonight. We're going to bring this to another meeting, fresh in our mind, with an indication of where we're going with this. That's why I asked. That's why I asked. Yeah, that's why I asked. So let's see what happens.
Ideas to work. But
No, exactly.
throw that.
They're on the street now. They can't be homeless. No.
Not that complicated.
All right.
No, I'm sorry. No. I would think this is what I think is
Some more BS.
what
Tell
I
them.
think is going
Let me just hear where you guys came from.
Well, that's why I wanted to.
You
Right.
said both said at the beginning. So listen, we get this. You said both said so.
Now you got time.
and it's got to play in the world. And rather than get something, look to statutes for what the face value of this statute. We're trying to find ways to make interpretations.
How you doing otherwise? You all right? All right.
I gotta call you.
The developer had
No problem. When you're ready.
city could issue the certificate of occupancy. Didn't do it. When you go and sit back and start making stuff like this crazy.
We just got another out. We gotta
We should be out by 8:30 or something.
be out.
Thank you so much. Thank
Right. Come on, I ain't with this stuff. I wish. It's in your hot lap, right? Right now, I'm trying to get a right to problem. It's a little early. It is, but all the things are possible. No matter what. They say it's like, I saw I ran into the reading. I heard so too. He was very coy with me. I got right in front of him. So where do we start? We gotta take a ride. I brought my girl. Yeah, it's good enough time. And the Falcon Doors. I want the S. I want the Model S. I want the Model S. I want the sports. S is the most one. Yeah, but yeah. Sport is sharp, right? What's up with the Lucid? What's up with the Lucid? Yeah. Lucid has a car.
So your choices are to either have that discussion now or to have it at the next meeting.
It's a nice car.
You do like it. You can set this meeting on area.
You say no? No, I'm happy with my car. I don't like the grass being a little greener on the side. Because I just bought it. It's like a year old. I never